Let's pray. Father, as we come together this afternoon to deliberate on issues concerning this committee and our country by extension, we ask for your guidance. We ask that whatever we may say or do will be in the best interest of all of us and the entire Jamaica. We ask for journeying mercies for those who are on their way. These and other mercies we do ask in your name. Amen.
Amen. Thank you. We have two apologies for absence, one from Member Golden, one from Member Charles. So welcome again.
Senator Scott Motley.
Senator Scott Motley. All right, I know others are on the way. We pray for their safe journey here. We'll move now to the reading and confirmation of the minutes of the meeting held on November 27, 2019. We'll start by looking at page 1.
This is the November minutes or the December minutes you're going through? December.
Sorry, I was looking at the wrong thing. Sorry, thank you. December 4th, 2019. Looking at my stuff from. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11.
Chair, there's a typo with respect to my name in the last line of the paragraph headed over regulation.
Page 10.
Page 11.
Page 11. See? You got it? Oh, it's not Miss Grant. Page 12. Page 13. Page 14. Page 15. Finally, page 16. If there are no other corrections, I put to the members the minutes of December 4th, 2019. Moved by Member Cuthberg, seconded by Member Morgan. Thank you. Are there any matters arising from the minutes? Well, there are 3 matters arising from the minutes for discussion today. The first has to do with the opt-in, opt-out regime. Second has to do with a request from the DPP, and the third has to do with, I guess, our reach into international jurisdictions. Is that a good way of putting it? All right, excellent. So we'll begin the discussion on those matters.
Good afternoon, Chair and members. Thank you very much, Chair. On the last occasion we were here, the issue was raised in relation to the approach that was taken in the data protection bill related to direct marketing. Presently, the bill makes provision for data subjects to opt out, and it indicates that an individual may at any time by notice given orally or in writing to a controller require the controller to cease or not to begin processing for the purposes of direct marketing. We were asked to look at this regime and whether or not this particular regime existed elsewhere. Based on our research and our further review of the legislation, we recognize that the current scheme of the bill provides for an opt-in, opt-out, and what may be considered to be a soft opt-in as well measure. The opt-in occurs first because in order to process data, one, you have to indicate consent. That is, the data subject must give his or her consent, and the data controller is required to indicate at the time prior to processing, what was the purpose or purposes for which the data would be collected, and also the purpose or purposes for which the data would be used. And so there would have to be some consent which would be given on the part of the data subject for his or her data to be used for the purposes of direct marketing. That would be the opt-in. Thereafter, if it is that you have given that consent and you would like to withdraw the consent, that is, you no longer want to receive any further information or marketing information from that entity, then you have the right to opt out, and that is the right provided in Clause 11, the right to tell them to stop even before they have started, or if they have started, to stop or no longer continue processing your data for the purpose of direct marketing. What we have found is that there is what can be considered to be a soft opt-in. So if it is that your data was collected by an entity prior and a particular company prior to, and that company collected your information in furtherance of the provision of goods or services provided by that entity, then that entity could pray in aid the legitimate interests provision in Clause 23, subsection 1, subsection F, which stipulates that the processing is necessary for the purposes of legitimate interests pursued by the data controller or by any third party to whom the data are disclosed. From our research, one legitimate interest is, for example, if that entity would like to provide you with information about other goods and services that that particular entity has or is providing. That could be considered to be a legitimate interest. It wouldn't extend to providing you with information about another entity with whom you do not have that relationship, because the data would have been collected in furtherance of this particular customer-client relationship, and they want to do that. And thereafter, you have that clause 11 right to opt out of even receiving any further information from that entity with whom you have that business relationship. That is the current scheme that we have. We find that scheme exists currently in the UK, for example. They have a similar scheme. We see that scheme existing in other jurisdictions such as South Africa, and I've been very clear to say that in South Africa, though the language is different, the scheme is the same, where if it is that there is a relationship that already exists between the entity and a customer, then you could, in those circumstances, send information to your customer. Only difference is, provided at the time that the information was collected, you would have indicated to your customer that you would be using their data for the purpose of sending information about other goods and services that you are currently providing. Generally, when we look across jurisdictions, we find that many jurisdictions allow for opt-in from the standpoint of requiring consent to use the data in the manner that the manner stipulated by direct marketing, but they also provide for the opt-out, where if it is after you have given your consent, you no longer want to receive any further information, you can in fact opt out. I believe as well, one of the things that we would have seen is that even if you are using the legitimate interest exception, that of course, and our law provides for it, that legitimate interest exception is subject of course to the rights and freedoms or legitimate interests of the data subjects, and indeed it's a balancing act that has to be exercised. And elsewhere, what we have seen, the recommendation is that you treat it that you will always need consent first in order to use information for the purpose of direct marketing, and that is really should be the default position, just to ensure that you don't run afoul essentially of the data protection legislation.
Madam Chair, can these consent be given and taken orally? Because as orally, so it will be binding if it is. I don't know if they're finished. Okay.
Remember, it's there in clause 11 where it says a notice can be given orally or in writing to the data controller.
Could you guide me to the clause that governs the opt-in, the explicit opt-in? That you said 3, there is opt-in, opt-out, and soft opt-in. Could you give me the clause that guides the explicit opt-in provision in the bill?
If you look at clause 23, so it says, and clause 23 has to be read in conjunction with clause 10.3a and 22.1a. So I'll start with 10. All right. So let me start off by reading. I'm starting with clause 22. Clause 22 says that the first standard for processing is that personal data shall be processed fairly and lawfully, and in particular, it shall not be processed unless A, one of the conditions set out in clause 23 is met. In clause 23, one of the conditions referenced are that the data subject has given his consent to the processing. So that would be where you would start. That you would have had to give consent to the processing. The other circumstances are listed there as to the circumstances under which processing can take place if there is no consent. And F is one of those, legitimate interests.
So guide me. So the mischief that I am seeking to correct is a regime where companies use access to personal data in order to further their own business interest with their customers or allow other businesses to use their customers to push their products. So you're saying previously that the law already provides a block without consent of third party transfer of data from one data controller to another unless there is consent. That's correct? No, I just want, does,
No, I don't think that.
so does the law prevent, let's say, telecommunications company A from using my data to push the agenda of telecommunications or business B? So I sign up with that company, I give them my data. Does the law prevent them without my consent from sending me a text message to say, buy this piece of furniture from company B without my consent?
Okay, got you.
Correct.
Right, so that's the first mischief that we are seeking to fix.
That's clause 23A. That's what.
Robert, which law are you talking about?
This data, yes.
This piece of legislation you're talking about?
Yes.
Okay.
Right.
So sorry to interrupt, Robert. Which does point me to the specific provision. That would be 23A. That would answer his question.
Correct, because
Yes.
it would
Okay.
be consent based.
Have consent.
Right. Second piece of mischief that I was seeking to ventilate is where companies collect my data and under the pretense of promoting products bombard my phone with information about a myriad. So for example, let's say I'm company B and I have 10 different business engagements. I sell phone, I sell media services, I sell documents, I sell X. So you're saying to me that if I give consent to company A because I went to buy a phone to send me information about business that they have, that the soft opt-in that you spoke about allows them to then send me information about any reasonably relevant business that they may have within that same company. Am I correct? That is the mischief I'm seeking to prevent. Madam Chair.
But you're saying it's for one particular company that you give the consent for, and not for all of the entities that you, I guess, you own. Is that what you're saying?
What I'm trying to ask.
Say though that all the entities, all the separate entities would have to register and declare that they are collecting personal data.
I'm not talking about separate entities. I'm talking about one business that has different businesses, and I engage that business in one of their particular area. But then, because under the same umbrella, so you sell me phones, but you also sell me other packages, other financial services. So now you based on the law that exists here, you are now authorized to send me information about every other business that you do, even though the only thing I was interested in is a phone. What I'm asking the committee to guide me is whether or not I personally would prefer that there's an explicit statement that says you cannot send me information unless I give you the explicit authority to send me information. What you find a lot of the times is there's a commingling between purchasing a product and giving the authority to send information. So by signing a contract, so the contract has 20 clauses that governs everything, and at the bottom it says, by signing this contract you consent to X. However, in order for me to use that product, all the permissions are commingled into one thing. Right? So now I am put in a position where I can't use the product unless I sign this contract, but I don't want the information, but I want the product. And I don't know if the committee or some members of the committee appreciates, and maybe because I exist in the space and I see what is happening out there, where companies are using or abusing their dominance, prominence within the market, providing services that are essential in a modern world, to force consumers to give up their data and permission to use their data. So what I was wondering whether or not we should say, do not send me anything until I explicitly say it separate from any contract that relates to using your services. That's all I'm asking. Just let me be the one. Let me give you permission to send me that information. Don't commingle it with anything else. And I don't know if members of the committee would associate with my concern.
Let me ask though, in the case that Nesta identified, wouldn't they be in breach of 23A? And if they are in breach of 23A, they would be subject to some fine or sanction, because you have not given explicit permission for your data to be used by this third party. For every meaning, yeah. So you go to company A, you give them your information. Company A shares your information with other people who begin to market to you.
No, I think he's saying it's the same company, just different areas within
different
the same
areas.
company. Yeah.
Okay, so you would not have given company A permission to use the information to sell phone. That's a breach. So if that's a breach, then wouldn't there be some sanction?
So standard, in response to the question, member, standard 2, which treats with the purpose limitation, and that's clause 25, says that a personal data shall be obtained only for one or more specified and lawful purposes, and shall not be further processed in any manner incompatible with those purposes. So if the data controller indicates at the time that your consent is being sought that these are the purposes to which your data will be used or how we're going to process, which may include transferring to a third party. If you consent to that, then the data controller isn't in breach, because you would have consented to your data being used for that particular purpose, i.e. to be transferred to a third party for whether within the company or group of companies or someone external. So standard 2 works along with standard 1 and the requirement for consent to ensure that everything is the processing is purpose driven, and it is as indicated to the data subject and not on the whim of the data controller. So I would have given consent based on an outline of 1 or 2 or 10 purposes to which you're going to be putting or processing that data, and I have consented to all those purposes, unless you indicated that you weren't in agreement with one. And then we get to the point where I think Member Morgan is going, is what does that mean? Does that mean the service is not going to be, I'm not going to be able to access that service, which is a different point.
I think what I'm trying to, and I ask for your patience, what I'm trying to deal with is the commingling of consent to purchase a product and and to use my data. Is it explicitly said in the thing that, so when you, let's say I can use iPhone. When I buy an iPhone, there's a long 20-page contract agreement with Apple that also includes deep within it some fine print that they're allowed to send me promotional information. I cannot engage with Apple unless I sign that agreement. What I'm asking is, have we created a regime where a company cannot force me to use my data simply because I decide to buy them a product? Is the buying of the product separate from the using of my data to send information? And if it is not separate, why isn't it separate? Why must I pay for a service while at the same time being obligated to accept further information from you if I do not want to.
Through you, Chair, to the member. Member, we hear you loud and clear, and I believe if the committee is minded, we could look at including the concern by virtue of incorporating it in the definition of what consent means. I believe the CPC has some wording that could give you that. So in addition to how we have adjusted the definition of consent, we could also indicate that consent would not be freely given if it is required as a condition of supplying goods and services, which is essentially what it is that you are asking for. In that, with respect to that concern, and then just to say that you had indicated earlier concern about opting in being very explicit. This in South Africa, the way the provision is worded, I don't know if this would provide greater comfort. The South African provision stipulates when it speaks about direct marketing and unsolicited electronic communications, it says the processing of personal information of a data subject for the purpose of direct marketing by means of any form of electronic communication, including automatic calling machines, fax, SMS, or email, is prohibited, so it makes it a prohibition and then provides exceptions, unless the data subject has given his or her or its consent to the processing, or subject to subsection 3 is a customer of the responsible party. So what they have basically done is exactly what we are doing. The same thing I mentioned about requiring explicit consent or utilizing the prior relationship essentially. So that just that they have put the prohibition earlier. But at the end of the day, we're going to end up back at the same place in terms of how it will operate. As I indicated earlier, what was clearer meaning for what is the wording that was used, not in terms of the application, was that in the South African legislation it said if a responsible party may only process the personal information of a data subject who is a customer of the responsible party if the responsible party has obtained the contact details of the data subject in the context of a sale of a product or service, or B, for the purpose of direct marketing of the responsible party's own similar products or services, and if the data subject has been given a reasonable opportunity to object free of charge and in a manner free of unnecessary formality to such use of his, her, or its electronic details, A, at the time the information was collected, and B, on the occasion of each communication with the data subject. So it's just how they have put their particular provision.
Because I like the South African framing. I apologize. And that is not to say anything about your framing, which is also good. But I ask the question, is the South Africa framing concurrent with the essence of our because what I like about the South African one is that it enumerates various areas, and it also speaks about the explicit asking me if I want to be a part, rather than. So the issue I have, and I've been having this issue for years, which is quite interesting. I'm on this committee. I went to a remittance company once, and they wanted to know everything about me. They wanted to know where I worked, chair. They wanted to know everything.
That's a remittance company?
Yes, a remittance. I was not involved in certain pursuits. They wanted to know everything, and you find even the simplest of transactions in Jamaica. Yeah, even if the simplest of transactions, Chair, everybody is now collecting data. And everybody is using that data to leverage their business. So even if I want to engage with a company on a singular basis, that clause about similar product now puts me in peril where even if I want to pay you for that singular engagement and I do not want to engage with you ever again, I now have the situation where I am now going to wake up and see you bombarding me with marketing, and that is what I do not like. If I'm paying for a service, I should not then be subjected to your marketing unless I want it. As the member says, if I'm paying for something,
They collect the information from you at that point of service when they have to ask, get your consent to collect that information.
There's a gap in the legislation in my mind for similar service. So there's opt-in, yes, but if it is based on my listening that they have my data and they're promote. So let's say I bought a phone and they have another promotion coming next year, then they can send me information about a new phone. What if I don't want to engage with you on an...
Kadian, can you summarize for us?
Chair, just to ask, is it correct to say that merely by being someone's customer that you're deeming to consent to receiving marketing information from them? There's no need for explicit consent?
No, I wouldn't say that you're deemed to have consented. The context in which we were explaining it earlier was that if it is that you would have the way the bill is structured currently, is that the bill provides for a data processor to process your information using, as it were, legitimate interests. One concept of legitimate interest is where you already have an existing customer relationship, essentially, to provide that person with goods or services. What is clear is that if I'm providing you with more information in relation to the very specific service that you have asked for, that would be fine. The question is, if it is that I have other services for which you could benefit, whether or not that would constitute legitimate interest. And what we have seen is that if it is that the entity that collected your information is providing you with information about other products and services related to what would have been the basis of your initial relationship, then that could qualify as a legitimate interest and allow it to process your data for that particular purpose. The long and short of it.
And that's the challenge I have, Chair. The challenge I have is that the mere engagement with a business should not give them implicit permission to manipulate my data how they wish. Because if I just want the mechanic to fix a brake shoe and I will never go to the mechanic again, why would then this mechanic be sending me information when I've already paid for the service and ended that contractual relationship? So I don't know if, you know...
In engaging in that contractual relationship, that's what I'm saying, that's where you would give the consent for further information, wouldn't it? Yeah. At that point, you can say, no, don't send me any information.
But the law has a gap. The law has a gap in my mind where because I engage with you, there is implicit consent to give me information on similar services. And that's what she just explained, that there is that gap there where there are three levels. There is opt-in, opt-out, and soft opt-in. The soft opt-in is the similar product marketing.
But remember, I must persist. At that point, though, right? At the point of service. Right, but at the point of service, can't you say no, don't send me any other information? I don't want to hear any. Kadian, at the point of service, when you're engaging, right? In order to collect your information, first you have to give consent for it to be collected. And at that point, you can say, I don't want to hear anything from you. Yeah.
That's correct, and that's correct, Chair. Ms. Moore would have explained earlier that the purpose limitation would be what you would use, because you'd have indicated the purposes for which the data would be collected, and you would indicate that you don't want your data to be used for that particular purpose, the purpose of marketing. So you'd have indicated that at the time when the data would have been collected and you are given your consent.
So could we summarize where we are so we can put it to the committee?
So, Chair, my understanding of where we are on this matter is that that the clause 11 will remain as is, but where we would make the adjustment is in the definition of consent to ensure that consent is not tied to the provision of any good or service. And that adjustment will be made in the definition of consent.
In 11 or in the definition?
No, in the definition. Just to repeat, that clause 11 will remain as it is, and that where an adjustment would be made is in the definition of consent to allow consent to be as it is, freely given, and to not be considered to be freely given if consent is required as a condition of supplying goods or services.
Before you put it, I just want a clarity. I'm not rehashing. Just from my understanding. So when I come to you as a business person and I'm purchasing a product, there will be an explicit thing that asks me, do you want to receive promotional information from us, separate from the service contract that I'm signing? Is that what the law says?
It might be like that, or it might not be like that. So it could be, these are the purposes to which I am going to be putting those, or processing your data. So I will be processing your data, apart from selling you the service and providing you with the service, and billing you every month and so on, and sending your information if you default on that payment to a third party for collector, etc. It may add in that list for purposes of direct marketing. It might have in that list. So what we expect is that the data controllers would have a list of that nature presented to the customer data subject, and on reading that, you will say, well, I don't want this one. So you could strike through exactly at the direct marketing and say, no, well, that purpose I'm not consenting to, even though you sign at the bottom.
Define may for me. You said it may have. I want you to tell me what you mean by may. Because may and shall are two different things. I asked you, is it that when I go to do a business, you have already said you're going to change the definition of consent that says the consent for marketing and my contractual relationship will be separate. And then I said, will there be a specific thing that says, send me data, use my data for marketing purposes? You said it may have that in it.
No, it's how you framed the question originally.
I framed it
right. And all I'm saying is that they should. And they're required, based on standard 2, to tell you what the purpose or purposes for which the data is going to be processed, which would include, to the extent that it includes, if they want it for that, and that's one of the purposes to which they're going to be putting or processing the data, they would have to, so yes, it shall, they would have to tell you that it is going to be used for direct marketing. And then at that point, you would be saying, I do not consent to my data being used for this particular purpose of the laundry list of things that they might give you. It might be one purpose, which is direct marketing, which is highly unlikely. But of the list, you would say, I don't want my data to be used for this or that or that. But they have to tell you, because Standard 2 requires that the data subject be advised of the purpose or purposes for which the data is going to be processed. So they would have to tell you that they're going to be processing your data with a view to direct marketing, for direct marketing, and then you would have to be able to you would give your consent for consent, if you're minded. If you're not, then yeah.
The challenge I have with the two different explanations that you gave me a while ago is that the first one you said it may have it, then the next one you say it shall have it. Just show me in the law where it says that if you want to use my data for marketing, I have to give you permission. Where that is clause 10, clause 11.
No, I can't show you that. It's not worded like that, and I think Mrs. Smith-Newton would have taken you through the two standards, at least one standard, Standard 1, about lawful purposes, processing for lawful purposes, and the requirement for consent. And then what we would have added to that is the issue of Standard 2, which requires it to be processed for a purpose. But we cannot show you that that is not currently worded in the way that you would want to see it. The legislation has to be read as together.
Through the chair, finally, I won't detain you much longer. I am challenged in appreciating, especially in today's world, where our data is now a commodity and it is being used as a commodity, why there seems to be a reluctance to explicitly say to companies that you cannot use my data for marketing purposes unless I explicitly say you should use my data for marketing purposes.
That's what the legislation says. Yes.
It doesn't say it in the law.
No, you have to give consent for your data to be used. The data processor has to declare what it is that they're using. Yeah.
I think no, what Senator Morgan is trying to Senator Morgan is trying to say, when you read the South African, yes, and they enumerated all the different areas in terms of where you'll be prohibited to process the data. I think what he's trying to say, he would love to see something like that in our act.
Do you know why I'm detaining? Sorry, my part.
The areas.
The reason I'm detaining the committee is because prospectively we see where the world of data is going. Data, as I keep saying, is going to be the most valuable commodity in the future, and a person's data will now have value. It already has value. A person's identity also will have value. Who owns your data? If it is that once I give you consent to use my data for a particular purpose, then the consent has such implications, then I must be very clear from the instant that I am giving you consent for my data to use for X. And that's specifically for X, because this is where the market is going, where your data is...
I'll allow the technical persons to answer, but my only response to that is you put that direct marketing in the law and the companies rename it and call it something else. I don't know how you can. Yeah, but I mean, yeah.
Chair, the only problem I have with that is that if we start putting that in the legislation, there are so many other things that we may have to consider that you want to put in the legislation. One of the things that comes to mind is using your personal information, for example, for research, stuff like that, or experiment. I don't know. So I think the proposal that Ms. Murray made in terms of what would be on the form, and you stating expressly the things for which you agree or you do not agree for your information to be used, I think that should cover it. And the provider of the service now has a responsibility to list all the different areas or different things for which your information can be used and for which they're seeking consent. And once you take no to direct marketing, or then that in and of itself, I believe, should cover and should solve the problem that Senator
Morgan.
Morgan.
I'm not saying it. Senator Morgan has. And
But then again,
I really just don't think we need to put it in the law.
Then again, you and I asked a question earlier, because there might not be a form in terms of. I asked about oral agreement. So what if you have a oral consent?
You might have misinterpreted your question.
Because
Yes, the question we were responding to was whether or not in notifying the data controller that you do not want the direct marketing to continue, if that can be done orally or in orally in writing.
Consent in any way.
The entire scheme will require data controllers to develop within their respective organizations privacy policy and change the way that they are now interacting with customers and consumers. They will have to be very deliberate in presenting documents in a way that we described earlier, so that they can explicitly receive consent.
Plus, what they present to you as a data subject has to be consistent with what they declared to the Information Commission that they are going to collect.
Absolutely, Chair. Because the register that has to be maintained with the Commissioner would outline the purposes for which the data is going to be processed. Absolutely.
Section 69, subsection 1, direct marketing by means of unsolicited electronic communications. The processing of personal information of a data subject for the purpose of direct marketing by means of any form of electronic communication, including automatic calling machines, facsimile machines, SMS, or email, is prohibited unless the data subject, A, has given his, her, or its consent to the processing, or B, is, subject to subsection 3, a customer of the responsible party. A responsible party may approach a data subject, 1, whose consent is required in terms of subsection 1A, and 2, who has not previously withheld such consent only once in order to request the consent of the data subject. The data subject's consent must be represented in the prescribed manner and form. The responsible party may only process the personal information of a data subject who is a customer of the responsible party in terms of subsection 1b, a, if the responsible party has obtained the contact details of the data subject in the context of the sale of a product or service, b, for the purpose of direct marketing of the responsible party's own similar products or services, and c, if the data subject has been given a reasonable opportunity to object, free of charge, and in a manner free of unnecessary formality, to such use of his, her, or its electronic details, 1, at the time when the information was collected, and on the occasion of each communication with the data subject for the purpose of marketing, if the data subject has not initially refused such use. Any communication for the purpose of direct marketing must contain a, details of the identity of the sender or the person on whose behalf the communication has been sent, and b, an address or other contact details to which the recipient may send a request that such communications cease. It is a provision on direct marketing. In terms of the an explicit prohibition, we can check.
Why are we so resistant in adopting such a?
I don't think we're resistant. It's just isn't
Let
it
me
up to
explain.
us?
So let me explain.
It's up to us,
I
isn't it?
withdraw. But let me ask this question. I love that phrasing, and I love the fact that at the beginning it's explicit, and at every occasion of communication, I get the explicit option to reject
Yeah.
or to opt out. And I'm trying to understand the reason why we could not do something, adopt that wording or frame it in a way that it works for our context.
Through you, Chair, we were speaking with the CPC, and we could include it in the scheme as a new 10 and delete 11, because if you notice the way the scheme is currently, 10 starts the rights. The right to do this, 11 is a right to, 12 is a right to. So it wouldn't fit nicely in where it is now. But I believe the CPC was saying it could be 10, and we'd push down renumber, I'm so sorry, more technical language. Renumber the clauses thereafter as 11, as well.
So it would replace the existing 11 as a new 11? No?
It
You're going to have both?
No, it would delete 11.
Okay.
We would delete 11, and the
And
new
use
formulation would become 10.
Yeah.
Right.
You're not going to have the his, her, or its, though, right, CP? The his, her, or its.
Nesta, Senator.
Um, s- MP Golden's intervention, I can be convinced to accept. Senator. If we're accepting the the South African way, is there amendment that is going to be made to the ETA? Will there need to be an amendment to the Electronic Transactions Act? Because I know last week you had referenced it.
I'm guided that this provision will be notwithstanding the provision of Section 29 in the Electronic Transactions Act. Wouldn't be troubling. No, we wouldn't. Summarize?
All right. Let me try to summarize then. We will have a new clause 10 patterned after the South African clause model, right, with regards to direct marketing and so on. We will delete clause 11, and then we will also make an adjustment in the definition of consent so that consent is not considered to be freely given if the data collection is required for service. So I put those amendments to members.
Agreed.
Agreed.
All right. Approved. Approved. All right, we have two other items to look at. The first one has to do with the DPP.
Thank you, Chair. So members will recall that at its last sitting, we would have indicated that it was the Office of the Director of Public Prosecution's view that investigative bodies ought not to be bound by the 7, and I say 7 because they're currently now exempted from 1 standard, the remaining 7 standards, unless these standards are also qualified in like manner. And the commitment of the ministry was to return to the committee with its research, having done its further research. What we have observed is that clauses related to exemptions for law enforcement in the Jamaican Data Protection Bill, as proposed, are in line with most of the jurisdictions explored. The general trend seen is to ensure exemptions relate to standards that, if observed, would compromise ongoing investigations or general law enforcement activity. All other standards are left without exemptions to ensure the general purpose of a data protection legislation regime is maintained. So we have looked at about 10 to 12 jurisdictions, and we only found 3 that provide blanket exemption for law enforcement. The others provided exemption for specific standards and were similar to ours, essentially. The standard that they would have been exempted from is standard 1, which relates to the need to obtain consent for processing, and the standard in relation to the rights of the data subject generally, but also standard 7, standard 8, which treats with third-party country transfer. And members will recall that maybe 2 sittings ago, the committee determined that for law enforcement purposes, standard 8, that is consent to transfer to a third party, or the third country rather, needing adequate level of protection, that standard would not have to be met by law enforcement agencies. So at this point, based on the recommendations from the committee, there are 2 standards that the law enforcement agencies would be exempted from. That's a standard in relation to not being able to transfer to a third country, and standard 1, which has to do with needing the consent of the data subject to be able to process. So our recommendation, Chair and committee members, is that the law enforcement agencies be required to comply with the other standards relating to data minimization, accuracy and update, storage limitation, and what we would call security and so on. That those standards also operate in the context of law enforcement agencies who are processing the data of data subjects.
Put it to the committee members.
Just query, which are the 3 jurisdictions which provide the complete exemption? You said there were 3 out of 12, was it?
Apologies. So we have Ghana, Philippines, no, my apologies, 2. South Africa, almost all the standards. They're at 6, but just 2. And then the UK has an exemption specific to law enforcement as well, but that is applying specifically the law enforcement directive of the EU.
Could you just explain that? What do you mean?
So the general data protection regulations currently does not apply to law enforcement agencies. It doesn't treat with it at all. So what would have occurred was that a separate directive would have been established in relation to law enforcement and their treatment with how they treat with or process data, personal data. And that directive itself was adopted whole scale by the UK. I would wish to point out that while the directive is in relation to trans-border or cross-border transfer, the UK would have gone one step further by applying it also domestically. So they're the only jurisdictions which we would have seen that would have done it in that way, applied it generally across the board to provide a full exemption for law enforcement to process data of the data subject.
Is there an amendment that needs to be made?
No, Chair.
Okay, all right. All right, we'll move on to the 3rd item. And where is Member Whittle? He's the one who was most concerned.
We would like to raise one other one. This wasn't discussed before. But the ministry is of the view that it would be appropriate, useful for a provision to be included in the legislation for its review. While we appreciate that a review of a piece of legislation can take place at any time, we would like to, as we would have been done with the Cybercrimes Act, for example, have a specific provision that requires the review of the legislation at a particular point in time.
Five years sounds good.
5 years from the commencement date.
Yeah, 5 years is good. We'll see how it works and if there are changes.
Is it full is it full rollout or so from full rollout then it's 5 years, correct? Okay.
What do you mean full rollout?
Can you repeat? Can you repeat exactly?
So you know
what
if 5 years doesn't start till the last piece of it is introduced? No, sir.
I want to hear the question you asked again.
It's going to end up being 7.
Can you repeat it again for me? What you asked?
Should be quicker, man. This is a fast-moving field. Yeah.
So it's fine. I think where my mind went in terms of where it starts is because I think the committee agreed is that what would be brought into force first would be those, the administrative elements of the legislation, those relating to the establishment of the office and so on. And so in my own mind, I thought that it would be more appropriate for it to start at a time when the entire legislation and all the other sections are brought into operation, as opposed to that particular one. But so if it's 5 years from that, I mean, if we start it before, yeah.
So the introductory provision that you have in mind contemplates different parts of that being brought into effect at different times. It may not be two stages, it may be 3, or it may be 4, or it may be whatever. So I think it should be 5 years from its first brought into effect.
With the advances in through the chair, with the advances in technology and how technology is used, which how quickly does I think processing speeds double,
and then implementation.
I think processing speeds double every 6 months, you know, which isn't that what data processing speeds?
But
so
some experience, I understand, but some experience has shown us when we have been doing reviews of laws that we need to give them time for us to be able to even get proper data to do a proper review. When we have been putting in 2-3 year review periods, by the time it's coming back to a joint select committee, there's really hardly any data. Remember now that also, I understand that technology, everything will be changing, but we are going to be also trying to review, Parliament would be trying to review, evaluate, monitor the parts of the Act that will depend on persons submitting reports, those reports being reviewed, and all of that takes time. I think if we do it too early, we're going to have a difficulty coming back to try and do a proper evaluation of how the Act operates.
The jurisdiction to see possibly, like, what is the period for their review? No?
Excuse.
Right. And that's the same thing I was thinking. It's even though things are changing so rapidly, I think we possibly need to give it some time. I mean, I am all for the 5 years.
And recall, Parliament has the power to determine and decide that they want to do an earlier review. In fact, we don't have to put in the review provision. What the review provision does is forces Parliament to have the review by a certain time, but Parliament always has that power to do it before, because
it normally says not later than anyway.
Right.
So you can have it
so
earlier.
It can be done before.
The technological advance. Sorry, Chairman, through you. The technological advances to how we communicate, to how data is produced, to even new types of data being created, I think warrant a more frequent review than a 5 year period. That is my own feeling. Much of how we communicate today will not be the same with how we communicate and how data is created this time next year. You're in an extremely fast moving space, and much of the changes are not something that we can contemplate in this chamber today. And I think, whereas I don't believe we have the capacity in the Parliament to review legislation every two years, that's really based on the speed that you'd want to be getting to. So 5 years is a little long, and 2 years maybe a little over ambitious. But 5 years is definitely too long for anything that is impacted in the way that this would be by technology.
Okay. Except that it says up to 5 years, and as SG said,
well,
Parliament can come back at any time.
Then I would make another comment.
Before you, through the chair, I associate with your concern in terms of collecting data, in terms of efficiency of the process. But this bill is not similar to any other in terms of its robustness, in terms of what it is seeking to deal with. It deals with an era that has been neglected for many decades, and an era that evolves every 6 months. Processing speeds, I think, double. And the processing speed is an indication of how the technology is advancing. If you give the option of up to 5 years, you're essentially creating a kind of situation where people say, oh, well, we have 5 years, when the reality that is on the ground, that is taking place in the marketplace, is functioning every 6 months. So you have to find a balance between the 2 and the 5, I think.
But except though that the reporting mechanism is not every 6 months as well. I mean, you
I
have
just
to
use the 6
factor
months.
in.
I just use the 6
No,
months as
I
an
understand,
indication.
but you have to still factor in when you're going to be doing a review of the law. You're going to be looking at not just that aspect of it, but also the other aspects, like how does the commissioner function? That's going to be something that you would have to review. I'm just saying, I hear your point. My other then comment would be, if you're going to use a shorter time, then it should be after full rollout. If it's going to be a shorter time, then it should be after the act is fully implemented, and
So
not at the
that's
first
actually going to mean a later
implementation.
review. If we do that, we're going to end up with a later review than a 5-year review after first rollout. The Chair, I think for some of these reviews, given the parliamentary constraints that we have, with only 63 MPs and 21 senators and all these mandatory committees that must meet, these discretionary things are difficult to schedule. And the truth is that if you give a 5-year window and it can be brought forward, if the law says not later than or up to, as you phrased it, if the matter is of concern, pressure can be brought from any parliamentarian to bring it forward because things have changed and the law needs to be looked at again. Yeah, and the minister initiates it, so typically, but if the minister is passive or not interested in the subject, others can bring pressure to bear to have it done. Chances are it will happen after the 5 years because, in the anti-gang legislation, there was a 3-year mandatory review. We didn't start till long after, so these things happen.
All right, 5 years from the first date. From the first commencement.
Yeah. I think I'll associate with that in light of the opinions of the technocrats.
All right, so moved? Approved. All right. So we'll move on to the final item as brought by Witter.
Right, so Chair, last week there was a concern raised with respect to the enforceability of actions against data controllers who exist outside of the jurisdiction. We did a little research, and what we found is we do have the legislative infrastructure that could accommodate that process domestically. But the bigger issue is in the absence of international agreements, there would be a challenge with enforcing it. And it was something we had been in discussion with the ministry earlier in the year. So we have the Judgments Foreign Reciprocal Enforcement Act and the Judgments and Award Reciprocal Enforcement, as well as the Civil Procedure Rules, which sort of provide a mechanism for service outside of the jurisdiction, but enforcing foreign judgments within. So I know in one recent case, the court or local court had indicated that the UK is one jurisdiction that we have that type of arrangement with. So that process would be a little bit easier. But in the absence internationally, or in the absence of having international agreement, it's just going to be a challenge that we will face. But we note from the GDPR that there are provisions in the GDPR which encourages member states to enter into these types of international agreements so that there is this fluency in enforcement. But until such time, at least we would have it, the infrastructure legislatively, so that when we get to that stage, it's just a matter of rolling it out.
Madam Chair, what sort of discussion did you have or engagement with the Ministry of Foreign Affairs with regards to this matter?
It's really a conflict of laws issue. There is a number of case law that we have surrounding this type of issue regarding enforcement, and we have our own legislation that deals with enforcement of foreign judgments. A discussion of that nature would not particularly be helpful because of the existing laws that we have. it would be a discussion at a higher level in terms of identifying those countries that would be willing to enter into these types of international agreement. So I know from a Commonwealth perspective, I know St. Lucia, for example, is one Commonwealth country that we have that type of arrangement with. So I couldn't go on record now as saying all the countries, but it's just to say the ministry would then need to consult through the appropriate channels to enter into these international agreements.
Yeah, but in terms of the initial discussions, I would think that you would engage the Ministry of Foreign Affairs.
Sorry. No member. In terms of we report on the law. If it is that the ministry with responsibility for the act realizes that there is an issue and wants to be able to enter into other agreements, that is when that ministry could then engage Ministry of Foreign Affairs, but it would need a cabinet decision. So it's not even so much, Foreign Affairs would only be able to assist in terms of having discussions with another country.
That is the point I'm trying to make.
But before they could do any of that, you would still need to have a cabinet decision.
Yeah,
Cabinet would have to determine whether this is optimal for Jamaica or not. And normally, before that happens, there usually is a reason. So there would have to be a rationale, a reason to approach Cabinet to say why you need to have this sort of arrangement with another country.
All right.
I have a question. In my research on this thing, I've looked at Google Spain SL and the Safe Harbor case where citizens were able to sue in the European Court Facebook and Google to cause them to do things. I think one was the right to be forgotten and the other one was the transfer of data. Is it that we do not have a similar ability, or you're saying it is more difficult for us for a citizen of Jamaica to act as Mr. Schrems did, or the other person in the Google Spain case?
The issue really is about enforcement of the judgment. The issue wasn't so much that we can't sue. That's not the issue. Because of course we can. The issue is if we get a judgment, if someone here gets a judgment, how do they enforce the judgment? So that is the context within which we gave that advice. So again, we have laws that allow for the enforcement of a judgment against an entity or an individual that's not Jamaican and doesn't reside in Jamaica, not here in Jamaica. But you have to have an international agreement for that to operate, as well as the legislative framework for that to operate. So that's all we were explaining. So there's nothing preventing the lawsuit. The issue is after the lawsuit, what happens?
Chair? I'm pretty new to the process, so I'm learning as I go along. Is it within the remit of the committee to make recommendations of that nature from a policy perspective regarding, in terms of creating the legislative framework to allow citizens to...
So we do have the act, but what the act will require is that we enter into a treaty arrangement.
Right, so that's what I'm asking. Is it within the remit of this committee to...
You mean to have the treaty arrangement?
To make that recommendation to the policymakers in that regard? That's what I'm asking. Chair?
SG, can you advise me if that can be done?
The committee can always, the committee can always make that kind of recommendation. Yes.
And would the committee be inclined to make such a recommendation? It would be
now in the report to Parliament, and then during the debate, because you do debate the report and any appendix which could mean amendments to the bill, then it could be raised in the debate and a decision could be taken by all members of Parliament on the issue about how to proceed. However, I would still say that when it comes on to international relations, Cabinet plays a role.
Not saying that we should I'm just asking if it is our remit to recommend a course of action, not to instruct a course of action.
All right, we'll capture it in the report.
What
the
could you summarize what the senator wants to recommend? Perhaps he could then, if not.
No, the SG, was it said that there is a legislative framework for persons to protect their rights within the courts if there's a violation. However, to extend it to act on the judgment would require a treaty. And I was asking if whether or not it is in the remit of this committee to make such a recommendation to the policymakers that they may want to consider such a treaty or whatever framework could work. I don't know, or a bilateral agreement, I don't know. So that's what I was asking.
We have a legislative framework already, but it requires for each jurisdiction for it to be extended to that jurisdiction on the basis that there's a reciprocal enforcement of judgments. So it would have to be a situation where they will enforce our judgments and we will enforce theirs. So we have that arrangement for some jurisdictions already, but relatively few. And so the recommendation would perhaps be for Foreign Affairs to pursue the possibility of having the reciprocal enforcement of judgments arrangements being extended to key jurisdictions where data is processed, Jamaicans' data is processed. And I think in the case of the United States, this is not done on a federal level, this is done on a state level, I believe. When I say this, I mean the reciprocal enforcement of judgments is done on a state level. I think there are a few states where we have it in place now, not very many. So for example, I don't think California is one, which is where a lot of these companies are headquartered. So this is something that perhaps could be pursued. Whether successfully, I don't know, but a try can be made.
All right, I put it to the committee that this recommendation be included in the report. So moved. Looks like a good time to move on to any other business. And if there isn't, let me take the opportunity to say thank you to all members present or in absentia for your dedication to this task. We've completed at least this phase of the interrogation of the bill. So let me thank Office of the Parliamentary Counsel, Ms. Judith Grant, the Attorney General's Chambers, Ms. Marlene Aldridge, Mrs. Marlene Aldridge, Mrs. Carissa Meledo, Mr. Andre Basco, Ms. Shelley Ann Thompson, Legal Reform Department, Ms. Erica Simon, Ministry of Science, Energy and Technology, Ms. Katie Ann Smith Newton, and our fearless leader, Ms. Murray, Ms. Chesan Brandon, Committee Clerk, Houses of Parliament. Thank you to Member Witter, Member Cuthbert Flynn, Member Julian Robinson, Member Golden, Senator Matthew Samuda, Senator Carencia Morrison, Senator Sophia Fraser-Binns, Senator Donna Scott Motley, Senator Robert Nesta Morgan, Senator the Honorable Pernell Charles, Mrs. Marissa Dalrymple-Philibert, Dr. Andrew Wheatley. This is a bill that has extended over at least 3 years to get us to this point. And so all of you deserve a round of applause to get us here. In terms of going forward, there will be a report put together by the Houses of Parliament. The report is expected to come to me by January 2nd, 2020. I commit to reading it and returning it by Friday, January 3rd. It will be sent to all the members so that you will be ready for the meeting on January 8th, 2020, to review the report before it's laid in Parliament. No. Okay. CRD. All right. So, sorry. Let me also acknowledge or highlight Miss Samantha Blair and the Hansard writers who have been so dedicated in their work. Yes. Well, let me give you the dates again. Houses of Parliament, Ms. Brandon said that she will send the report to me by January 2nd. I commit to reviewing it and returning it by the 3rd of January. Yes. And so that should be ready for you well before. Yes. It will be sent to you on the 3rd so that you can be ready for January 8th, 2020. So let it be. All right. If there are no other issues, business, comments, subtractions, additions. No. You'll get it before the 8th. Yes. You'll get it by the 3rd of January. 3rd of January is after Christmas. After Christmas. All right. Thank you so much. Thank you. Meeting stands adjourned. Thank you.